crowd here this morning, this afternoon, what is it? This afternoon, and we appreciate you coming out early and meeting with us tonight. We have some great speakers for you. As you know, we have Justin Cameron and Linda Mericle. I keep wanting to call you Cameron Mericle because it says Cameron Mericle.
Confuse people.
From Cameron Mericle. And we have Ruth Katz from Lerch, and Brewer talking about that. I want to thank South River Restoration, who provided, that gentleman right here, who has provided all the food for our program tonight and material. South River is a relatively new contractor working with us, although we have worked with them over the past year or so. And they come highly recommended, and they do emergency response teams and emergency maintenance, so we hope to be doing more work with them in the future, in the very near future. We have a big program, so I'm going to say goodbye. My name is Herzberger, by the way, and I'm the president of, I have to say that once in a while, but I'm really not part of the system anymore. We do have my partner in crime here is Teresa Edwards, and she's our Chief Operating Officer, and she's right there. And she's just been doing a wonderful job over this past year, and we have all kinds of people coming into our system. We have just had a young man, I don't know if he's here or not. Frederick, is he here? Who will be being promoted to Assistant Vice President of Accounting. He's been with us for a couple of years, and he's going to do a fantastic job. And we've had some setbacks this year, and we've lost some people. Carol Allen, many of you know, died earlier this fall, or the end of summer. And it's been a tough year for that. So she was sick for a while. But we were very happy, and we got a lot of new people. We've had 2 people retire in the past week. Ron Rims, if you're in the Timonium group, Ron's been with us for 18 years. And just today, Dorothy Roberts retired. She's been with us for 17 years. And we're going to miss the commitment those individuals gave to their clients in these past years. Exceptional people who came into the industry, sort of new to the industry when they came with us. So we're very proud we have a lot of people like that in our company who have learned the business and working with other team members here at ACM. So I do want to thank Sarah. Where's Sarah? She's left. She's put the program together for us, and we appreciate the fine work that she's done, and of course all the people who worked on this program today. And I'm going to turn it over now to, just for a moment, brief moment, to Heather. Heather, because Heather is really running a special team for us. Heather Griffing is our, I don't know what her title.
Corporate Administrative Services Manager.
There you go.
Girl Friday.
She's no, she's more than a girl. She's a girl every day of the week. So she is running this transition. I know all of you probably have heard by now that we are moving away from Northco, which was painful because we brought Northco to Baltimore into this market 6 years ago. But we had so many things we wanted to do, and so little flexibility in what they could provide, that we felt it was something that we had to do. So Heather and Christy is in our Timonium office, has been running the transition. It's been a lot of work for everybody. We appreciate your support in that. I think you're going to like it. I think we're adding some features that you're going to appreciate. Not the least of which is a to-do list that you'll be able to track issues with us and you. And we have an opportunity, which is something that I've always wanted, the ability for the homeowner to bring issues to the board that are not necessarily architectural or maintenance issues, but they are community-based issues. And we'll be able to track those as well. So we're very happy just with those two items. But there's a whole list of things that we're going to be able to do in Unify and manage that we haven't been able to do with Mericle. As I said, I know the folks at Mericle very well. They're great people, great program. We recommend them to all of our competitors. And we continue to do that, and we'll continue to do that, because I know they give them very good service. So we're on board and we're working hard. Now, one of the things we're going to be doing is we got a lot of information to move over. We want to move as much of it as we can. So she has already notified you that we will be closing our offices to the public on Friday afternoons through the month of November and maybe the month of part of December as well. We're here. The maintenance department is working. The issues that need to be addressed will be addressed. So we want to try to get as much information as we can before we pull the plug on Mericle December 31st. So I want to introduce you to Heather.
Sure, and I'll have one quick thing to say to all of that is, during this transition time, we've posted videos for board members. You will have access towards the end of November to the new site. There's a video and a 2-page item that you can read through that tells you how to use the site. If you've used a site like Amazon or Walmart or Target.com, it's very similar. You go on, you click a few buttons, voila, you're there. It doesn't require a lot of training, which is why we moved to this new system. However, we will do a training towards the end of December once everyone's gotten onto the system. For everyone, be a go-to-meeting, you can log in from home or after work, whatever works for you. Love your feedback, recommendations, and everything. Please keep it coming. Your feedback is what has created this new system, so thank you.
Thank you very much.
Yeah.
Yes, sir.
What's the name of the new one?
It's called Unify, U-N-I-F-Y.
Let me just say, as you know, I mean, I've talked to many of you when we came to sell you our service. This is always something that we've wanted to do. We've always wanted to give the boards and the homeowners the ability to gather information, to see information, to make things available to them when they need it. We have an astounding number of homeowners that are members, somewhere in the neighborhood of 18,000 to 19,000 of the 25,000 homes that are in working with ACM are members of Mericle and will be members automatically of eUnify. Other companies don't do that. They don't want to do that. And that was some of the issues that we had with our friends at Mericle. They said, you know, the things you ask for, other companies don't want, so we're not going to spend the money to do it, which is a good business decision. For Mericle, it just wasn't a good business decision for us. So we want to do more things like this, and we will continue to do that. That's why we have the board making this thing with our little company here in Columbia, and we're going to continue to do things like that. I know not everybody wants it or needs it or thinks that it should be done. I'm sorry, but you know, when we started with Mericle, one of the sales features was that now you can get rid of all your people, because everything is online, and so you don't need all those administrative people and phone answering people and maintenance people. And I said, well, maybe not. So I keep waiting every year. I come back and I ask the managers of the company, when can we get rid of those 70 people that keep paychecks from us? And I know and they know that we can't do that. But we do want something that is a good administrative and accounting package. We have a good accounting package, primarily because we have a good accounting package. And now we're going to have a good administrative package to go with it. So thank you very much, and I'll turn this over now to
Did you have a question?
I was just going to ask if all the information you currently have from us,
Yes.
will it have to be re-given to you?
We have everything that we've been able to archive from Mericle and ACM Home, and we're transitioning that every Friday from 1 to 5. So it'll all be on the new site. And I believe the South River, want to talk for a minute or two? Yeah.
Well,
No,
before,
okay, all
while
right.
we're getting him
He's
from
coming, okay.
Bologna in there, Charlene Pindell is our regional manager, and Sherry Kortok, our regional manager, and they have, those of you who know that what we've been through the last couple months, these young ladies have worked very hard to make sure that our service is continuous until we get everybody in place. So I want to thank them for their support. Joanne, would you like to tell people who you are?
Yeah, I don't want to take too much of your time, but I just want to thank ACM. I'm Jay Calloway, South River Restoration. I want to thank ACM for letting us come in to, sponsor this seminar right here. And we are a full-service restoration company. We're fairly new to ACM. They given us some opportunities on a couple of properties. That's about it. I appreciate you guys coming out. Thank you.
Thank you. Thank you very much.
Hi everyone, welcome to American Community Management. I'm Joanne Allen. I'm the Accounts Receivable Collections Manager. Today for our seminar we have Ruth Katz. She works at Lerch and Brewer. And Ruth helps community association managers and boards with general condominium, homeowners associations, and cooperative issues. And then we have Justin Cameron, who works for Cameron Mericle, and Linda's also here, his partner. And he has significant experience in condominium and homeowners association law while working as a law clerk in Florida. And he started working with Linda Miracle's office in 2012. So we're going to start out with each of them with presentation, and then we will get to questions and answers after for the last hour. Okay?
Sure.
All right.
Good afternoon. Thank you, ACM. Thank you so much for having us. What a great seminar you guys have put on. Thank you all of you for being here to learn with us. I'm going to be speaking a little bit about legislation. And Community Association has had increased amount of legislation passed through the Maryland legislature. So we're going to talk about what passed, what didn't, what we're going to see coming in the future, and all of this relates to what you see on a day-to-day basis. So if you have any questions, please feel free to jump in. We'll also talk about some federal issues and potentially some local ones. So I currently serve, and thank you for the wonderful introduction. I'm just going to supplement a little bit. I currently serve on the Maryland LACS, the Maryland Legislative Action Committee, on behalf of Community Association Institute, which helps lobby and write testimony on behalf of community association issues at the state level. So the legislative session occurs between January and April. It's very busy, and right now is actually a really good time to have this seminar because they're off session, and now is when our committee talks about what initiatives we're going to bring next year. What are things that our boards and our owners and our managers are seeing that are an issue that we can bring to the legislature's attention. We actually have some new legislatures that came on last year, and one of the things that we've been doing is really educating them on what is a community association, how do they operate, what are the issues, what's important, in hopes that the legislation that we see will be a product of that. So feel free to follow along. I think you guys have, I hope everyone has the PowerPoint. So there were 3 bills that passed in the 2016 legislative session. The first one was resale disclosures. And this is a bill that was in and out and got introduced several times. I think it started coming in like 2014, 2015, and it kept failing. And it came about as a result of an owner that said that they were charged $750 for a resale disclosure package. So when you sell the property, the association and your managers that work really hard prepare a resale disclosure of certain line items, are there any current violations, assessment issues, etc. And someone said that they were charged $750, which got the legislature's attention, and they decided to legislate it. Initially, the bill, as it was introduced, came about, I think they wanted to cap the resale fee, so the fee for the resale package at $75. And the idea was that they thought your managers just press a button to make the resale disclosure package appear, which I'm sure all your managers can attest that it takes a lot more than just pushing a button to get all that information to the proper owners. So the legislation that did pass in 2016 said that there will be a cap of $250 for each resale disclosure package that's provided. There's also an allowance for a rush fee, $50 for a resale disclosure package that was requested to be produced within 14 days and $100 for one within 7 days. Also, there's a UPI increase every 2 years. One of the other things that it did, though, this bill, aside from the fees, is that it modified the contents of the certificate. And why that's important is that there was a case several years back where there was issue with a special assessment that hadn't yet been adopted, and there was an argument that the association had to disclose this potential special assessment. And then there was a question with all the attorneys, at what time do you actually disclose when a special assessment may or may not be levied? Do you do it when it's adopted? Do you do it when it's proposed? There was a lot of uncertainty. So what this bill did, in addition, is say that expenses or special assessments adopted by the Council of Unit Owners have to be disclosed. So just because a special assessment or assessment increase is discussed or proposed, and there's a future meeting to adopt that special assessment, doesn't mean that you have to disclose it on your resale package. This is only assessments that are adopted. So that's one good clarifying point.
What would the expenses be, other than the monthly condo fee?
So, let's see. If you have like a maintenance program, like a in-unit maintenance program, and there's going to be increases.
Some condominiums have utilities separate from
Or utilities separate from the assessments, that's another one. You know, for the most part, we see them in special assessment, but this is really anything that can be levied.
So utilities and what else? Utilities and,
So, like in-unit maintenance, some have in-unit maintenance fees.
I guess we don't, because I don't know that.
Yeah,
would be.
you're mainly going to see this in assessments and special assessments. Special assessments mainly, yeah. And the other kind of good change for associations in terms of solidifying what the contents require of the certificate is that it required actual knowledge of any violation of a health or building code. So before this previous case said that it could be building code violations that were known or should have been known. And this actually says actual building code violations. So when you're cited for a building code violation, then you disclose it on the resale certificate. So just items that are trying to clarify what you need to disclose. So one of the case also indicated, one I'm referring to a couple years ago, said that associations can be subject to Consumer Protection Act violations for violations of these resale certificate disclosures. That's why it was so important for us to ensure that it was clear as to what needed to be disclosed.
Question. So when a property is changing hands and you give them this resale package,
Yep.
can the association put in there, look, you need to be aware, your garage door is going to need to be replaced, it's damaged, you know, fix
Yep.
the doorbell, this, that can all be...
Yes,
good.
yeah. And in fact, I mean, if those are violations, we would say that you should put them in there, right?
Good to know.
Right. So, yeah, absolutely. And what I've found, we've actually had a couple of these cases litigated, and, you know, I don't want to say more is better, but, you know, in some instances, more is better, especially if there's violations. You want to ensure that those are all listed. Now, notably, one of the other things that this bill does is it says that the association can charge an additional $100 for inspections of the unit, and that was excluded, I think, in error from the homeowners association bill. That's going to be coming up in the next legislative session to remedy that. But while there's no requirement that you do an inspection, if there is, absolutely cite those things, and you could charge an extra fee for that. I don't know, I think you in the back, you're first.
I'm a bit confused, and I represent homeowners association.
Sure.
We aren't involved at all in this process. and I hear you saying the association should or might do.
Right.
What is our role? Do we have a role?
Your role is to hire a good management company.
Right, so the management company.
Which you did. I mean, this primarily is done by the management company,
Okay,
right?
that's my assumption.
It is. Primarily it's done by the management company, but this is important. These are things that are important to note because, you know, when you adopt these special assessments, it doesn't hurt to say, I heard Ruth Katz speak and we should put this in our resale disclosure package. I mean, between your attorney and your manager, I mean, you guys have good management companies, so they know these things. And but, you know, I say association because they're also your agent. And if there is a lawsuit or anything, then it's the association is going to likely be sued. We've had the association and the management company be sued. So we want to ensure that everyone kind of understands what the regulations are.
I would like to say something though. What we've recently become involved with on the resale packages is, and we're a relatively new community, is that improvements may have been made on the lot where there wasn't an application that was submitted to the ARC. The management company is not always aware of that, and so we've added a bit of a step to make sure that when the resale package is someone from the ARC goes out and takes a look at the property, and if they recognize that there's been an improvement made, particularly one that might be an issue, that goes into the resale package.
Is there such a thing as a resale package for a co-op?
So there is not a resale package requirement. I actually dealt with this recently. There isn't wait, hold on. Let me look at that because I actually dealt with that exact issue recently, and I believe there are some requirements, but it's not the same. It's not the same structure as the homeowners association and the condominium.
If you had an issue with your building where there's something that has some unusual wear and tear, I mean, over a long period of time, 40 years.
Right.
Do you think someone could make a case that that should have been disclosed?
So what this actual case talked about, this case 2 years ago that dealt with somewhat of a similar issue, is that if there's some deception in the documents that you're providing, then there can be a problem. But if your budget and if the documents surrounding your resale disclosure package are showing that you're dealing with this maintenance issue, there isn't going to be some big fee coming down the pipe years ago that the owner should have known about.
It's actually a hidden, it's actually a hidden issue. I mean, It's not visible to, it's not until someone tears a certain part of their unit out that you think, oh, this has to be fixed. And it falls on the condo association to fix it under our bylaws.
Okay.
But,
so if it's a known condition, I would lean towards disclosure as opposed to not. I mean, there's some pretty high. We could talk kind of offline about the specific issue.
I don't think it's a violation of a health or building
code. Okay, let's talk more offline. But just generally, we always say lean towards disclosure versus not, because the repercussions for failure to disclose are relatively high. Thank you. But it may not be something that you have to disclose. We could talk about it.
If that case is, I think, recently foreclosure.
Yeah.
When the bank that bought it didn't go through the resale package at all, just bypassed us completely. Do we have any recourse, or are they more liable for things? What's the consequence of that?
Is it a condo?
It's a condo, yes.
Okay. So. Yes, so they're still obligated for anything that they would have been So what the resale disclosure package lets them know is this is the condition of the unit. These are the fees that are owed. That doesn't change just because they failed to ask, and it happens quite frequently. So no, but that doesn't change their obligation. Yeah.
I'm in a community that has 2 condominiums.
Okay.
And also above those is one homeowners association. All the condo lots are part of the homeowners association. Which has to provide the resale package, or do both have to provide a separate resale package?
Both, and they can charge $250 for one, $250 for You said there's 2 condos? So 250 for one and 250 for the association.
My question is, certainly condo A does not have to provide
Condo
resale
Bs.
packages for condo B.
Right.
But
So-
does the homeowners association have to provide an extra resale package
Yes.
for both the condos?
Yes. So it's the seller's obligation to provide, under a homeowners association context, it's the seller's obligation to provide that resale disclosure. But yes, if they're requesting one from the condo, one from the HOA, yes. And 250 for one, 250 for the other.
Can the management company combine those two into one package?
You can, I don't know, what are you guys doing with that? I think there's gonna be different obligations, there's gonna be different condo fees for each.
We do resale for both, but we put it in one
Package. Yeah. If that makes sense. But you can charge double the fee for that. I don't know what your, any other question on resale disclosure packages? The next one is tax sales. And this was a bill that CAI supported, and it provides that an association will get notice of a tax sale once it's docketed with the court system. So in a tax sale contest, the purchaser at the tax sale purchases at the tax sale. But in order to transfer title, they have to get a court order, or they have to what's called foreclose on the equity of redemption. And typically, when these tax sale purchasers were filing in court, they would only notify the association if the association had a lien on the property. So if we had some type of interest in the property. So this bill now says, and we want to know what's going on with these properties. So it says that if you file to foreclose the equity of redemption, you will notify the association. This is another bill that CAI supported. We've been seeing tax sales fairly frequently now, so this is just one to note as well. And then the third is collection of assessments. And just to put, this is the last one that I'm going to talk about on a state level that actually passed. But just so you guys know, there are over 1,000 or 2,500 bills that were introduced in this legislative session, 100 of which related in some fashion to community associations, 60 of which we wrote legislation on, either opposing, supporting, or supporting or opposing with amendments. So the fact that 3 passed is interesting. It just shows the trend that people are legislating and more interested in community association issues. We're seeing it on the state level. And it's very important for us that these guys know as much as you guys know about what it is to live in a community association. So a lot of the bills that came out were bad bills. So we're happy with the 3 bills that did come out. Some of them were good that we're hoping to come up in the next legislative session. But just to give a little bit of context to the fact that we're only talking about 3 bills today, we're dealing with on the state level, like 60 plus that we took positions on. So the third is collection of assessments. With respect to collection of assessments, this bill is a restriction, and maybe I spoke too soon about we're happy with these 3 bills. This one I'm not so happy about, but it actually started in a much worse form. So the form that it came out to us isn't as bad as where we started with it. So what this bill says is that a creditor may not file a claim if the statute of limitations for that claim has run. So in a breach of contract claim that collection of assessments typically fall under, it's 3 years in Maryland. And in the court system, statute of limitations is what's called an affirmative defense. So you can bring the claim, but if the other side says, "Oh, wait a second, statute of limitations," then your claim is barred. Well, this is making it affirmatively illegal to bring that kind of claim for more than 3 years. And I can tell you that our office has been pretty cognizant of this 3-year statute of limitations. This doesn't really affect how we're doing business because we ensure that our claims don't run past that time period, because there are other potential federal debt collection practices issues, but this was now codified in Maryland that you cannot bring a claim within, that's exceeded the 3 years. Okay. So that's the last bill. I think CAI opposed this bill to ensure, or because we didn't want additional restrictions on creditors. Collections, which Justin and Linda are going to talk about soon, is tough enough as it is. So, our kind of thought was not to place as additional restrictions, but this is the bill that came out. It's not horrible, but again, something to be aware of. So that's it, the 3 bills.
If someone hasn't paid their assessment,
Yeah.
we're talking, a homeowner hasn't paid their assessment, you can't go after them after 3 years, is that what this says?
So no, what this says is that if you don't have a lawsuit filed, if you don't have a claim filed in the court system within 3 years, so if you've let the assessments lapse, let's say you were looking at assessments from January of 2012, and you haven't done anything, you haven't gotten a judgment, filing the lawsuit now is now barred by the statute of limitations for that portion of the debt that exceeds the 3-year period. So you can still bring it from October, what day are we on, 26, 2016 forward, but that piece that isn't secured is barred by the statute of limitations. Now, if you filed a judgment, let's just say that debt again originated in January of 2013, and you filed a judgment in, or you've obtained a judgment in January of 2014, and the debt is still owing, nothing prevents you from continuing to go after these people or to seek that amount that's owed. Judgments in Maryland are good for 12 years and renewable for another 12. So there's nothing preventing you, you just have to have that judgment. It's just where there's an open, unsecured amount out there that's the problem.
In the case that you just mentioned,
Yeah.
you could go after them for 3 years back. So here we are, October of 2016, you could go back to 12 or
13, yeah. So tomorrow I'm filing a lawsuit from October 27, 2016 through October 13 through October 27, 16.
So a property lien would secure a debt, would it not?
So not for this. So yes, it would absolutely secure a debt against the property. So if you have a lien that's recorded for debt from 2012 and someone wants to sell their property tomorrow, you can absolutely say you have a lien and you're paying off the lien prior to the transfer of property. Absolutely. But this strictly relates to the court action, so obtaining a judgment. The lien
you couldn't obtain a personal judgment then for that lien that was filed in 2012?
Yeah, so even if you have a lien secured in 2012, I couldn't go to the court and say, well, I had a lien, I'm going to file a judgment now too. That's still barred by the statute of limitations. Doesn't mean, again, that when the property sells you can't collect on that lien, but you can't obtain a judgment for that. Does that make sense?
If they make a payment during that 3-year period, does the statute of limitations start all over again?
No. So, if they make a payment, that's a great thing. And there's certain ways that you can kind of get around. I don't want to steal if you guys are going to talk about it.
You're fine.
Okay.
So far,
Okay. I don't want to step on toes because I know they've got a big collection thing for you guys, and that's potentially a little bit more sexy, even though I like legislation. But anyway, but there are ways to deal with the statute of limitations. Just making a payment isn't going to be enough. There's certain case law and legislation that says that if you enter into an agreement, so if they agree that the debt is owed, then that bars or dispenses of any claim for under statute of limitations. So one of the things, if an owner contacts you and you're about to file suit, you're past the statute of limitations, and they agree that the amount is owed, that kind of retolls, because now you've got that agreement in front of you, and that agreement is you know, in order to let the statute of limitations run out on that, it's going to be 3 years from the breach of that agreement. So you kind of retold the whole process.
So if you had a promissory note,
Right.
it would keep it alive.
Exactly. So that's, I know this is like the good collection, you know, smart collection tool. So that's one of them. But, you know, just again, be aware of that if you have these debts, I have a lot of board members that, you know, maybe the assessment isn't high enough yet, you know, it's a year or two, and they don't want to spend, you know, money chasing after a low amount, and so they'll kind of let it linger. So kind of the cautionary tale here is to don't let them linger too long and do a check-in. And Joanne is actually wonderful about that. You have kind of a good checks and balances for you because you know, you just don't want to let that time expire, and then you kind of look at it and you're like, oh, I've got an unsecured debt from 2011. Why didn't we do anything about it? So that's kind of the cautionary tale of this legislation. So those are the 3 bills that passed this legislative session. We'll go again in 2016 or 2017. But I did want to kind of highlight what's to come. What are the hot button issues? What are we hearing from people?
Earlier, excuse me, earlier this month I went to the CAI Expo. And the LAC will discuss bills at that. And it was stated that this homeowners association not appearing along with condo associations for inspections, which you mentioned, was likely to be reintroduced. However, the lawyer who spoke to us said it probably won't be, or we're not going to push for it, because if we reintroduce that, it opens up that whole law, and horrible things can happen when the legislature gets a hold of laws relating to entities like associations, community associations, that they are opposed to.
Yes, so that's actually a great segue. I'm going to answer your question, but that's also going to be a great segue into my first point on the legislative forecast. So my understanding is actually one of the delegates is going to be introducing it and has already written that language into it. But yes, CAI is stepping back a little bit for that exact reason. And if it gets introduced, we're going to support that amendment. But you're absolutely right that sometimes you don't want to be at the forefront for them to kind of retake a look at it and say, we're going to change the whole parameter. We want to change the whole structure of it. And to that exact point, one of the things that we're talking about in this interim period is the law relating to insurance deductibles and pipe bursts. So, you know, one of the things that we hear about almost on a daily basis from associations are the frustration when a pipe bursts and it's due to an owner's negligence because they're not living there full time and they didn't keep the heat on or whatever the case may be, and it triggers the association's master policy. And even as a result of the owner's negligence, what 11114 of the Condominium Act says is that you can only assess them up to $5,000 if the damage, based on where the damage originated, but only at a maximum up to $5,000. So we're seeing problems with associations that have, let's say the damage caused was $30,000 and an association has a deductible of $25,000. I mean, it's somewhat frustrating to these associations that are saying, but it was as a result of this owner's negligence, right? So we're having a lot of conversations right now to try and deal with that. But one of the issues that we're running into is how do you carve out something that's helpful to the associations without doing exactly what you mentioned, which was bring 11114 to the legislature's table, and then they could take a look at it and say, whoa, wait a second, we don't even like this. At least what we have now, I tell you, I also practice in Virginia, is structured. It tells you what is, what isn't. So we were talking about increasing the 5,000 to 10,000, doing all types of things. So we're still trying to come up with kind of a creative way to address the problem without creating more of a problem. And that exact balance is what we see all the time. Yeah.
And this question came up in my mind recently, when you have, I mean, I'm familiar with that $5,000.
Right.
But what if you have a claim, well, maybe I've just, if you have a claim that you don't put into your insurance
Self-insured.
company, so
Yeah.
you can still collect $5,000 from the unit where the issue.
The damage originated.
Yeah.
Yeah, so, I mean, if you choose to self-insure, the way the statute is written is, if it's an insured casualty, regardless of whether you put it into insurance or not, you're still going to have to make the repairs, right? So that's kind of like the general rule. This hasn't been specifically stated or legislated, and I think there are arguments on all sides. Our position is that, yes, even though you don't submit it to insurance, you could still seek to obtain, it's still an insured casualty, the damage still arose in the unit, and you could still attempt to obtain the $5,000 from the owner. So the triggering is what the casualty is,
Right, whether
not
it's a
whether
loss, a peril that's covered.
Exactly, not whether or not you submit it to insurance.
When you have something like that happen, I mean, I think sometimes it's, in our particular condo, we're a garden condo, but we don't have individual water heaters. I've heard that story over the years, of it. The water heater in the unit above me gave out, which they do. But, which might be negligent maintenance, but can, say the unit owner on the second floor, you know, they've had all their, they've had all their, what's covered by the condo association bylaws, for, which is the condominium association's responsibility, replaced by the condo association. But then the owner says, well, you know, my furniture's been damaged, I had to go live someplace else for a while, and, you know, I need rents. Do they get to
submit to your HO6 carrier, neighbor, I mean, as far as the
just
association.
let them handle it? I mean,
yes.
I mean, that we have unit owners that are screaming about, it's their negligence. Well, yeah, go to your carrier, let their carrier go to their carrier.
Right, so.
The other person's carrier.
So
Talk to your legislator.
Talk
to your legislator.
So which brings into the exact point that I'm saying, you know, we want to fix this problem, but
so
kind of
what
delicately.
Is the fix that needs to be done?
So, you know, the fix is for negligence, with respect to the association.
Action for negligence?
Yeah, I mean, the problem is we're seeing more and more of these as a result of owner negligence. But
I'm sorry, are you saying an action for negligence by the condo association against the unit owner? Or an action by the neighboring condos against the responsible unit owner?
So, neither. All I'm saying is that we want to address the problem of negligence somehow in legislation. And then the question is, what form does that come in without disturbing the structure and the framework of what we have?
Yeah, because our bylaws have hold harmless agreements.
Yeah, so as far as, you know, our master policy is going to cover the drywall, the floor, you know, kind of the four walls and the four corners. If you're talking about displacement and furniture, and we just had one today, your hardwood flooring, those are kind of betterments, improvements, personal property. That's not typically covered under the master policy. So that would be submit to your HO6 carrier unit, or if you want to go after the other person, you may have a claim in that, you know, that we're going to step, our typical line is submit it to your HO6 carrier.
Yeah, that would be mine.
Right. So, but a hot button issue, a very hot button issue that we kind of want to bring up, but delicately. You know, foreclosure, bills relating to foreclosure, we see them typically. A lot of them are very bank friendly, and we've been successful in defeating them. But one of the things that, you know, comes up time and time again are, you know, the banks aren't foreclosing. They're delinquent, they're behind on their mortgage. The bank's not foreclosing, they're driving us bananas. So we've been talking a lot about that. Also, bills relating to, you know, recordation of deeds by the bank when they do foreclose. They just kind of let it kind of hang out there in oblivion. So that's always on our mind too. That's what we see time and time again in our practice. Other wish list items, and I just kind of wrote this because we've been talking about, we just had a meeting last week where people brought up kind of all the issues that we're seeing. Finding authority for HOAs. So right now, unless you're governing documents, and I don't know if you guys are talking about the Elverton case or you want me to. Okay. So,
There's so much material. but
there's
take
tons,
it
yeah,
out.
there's tons of material. We could talk for hours, and all of us. I love what I don't want to speak for you guys, but I assume like you love what you do, so we could stand up here and talk to you guys about this for hours. So I will try to make this short. But so finding authorities for HOAs, something that deals with, there was a case that said that unless expressly authorized in the declaration or bylaws, you can't suspend privileges like pool passes and parking privileges. Well, then what do you have hanging over these delinquent owners' heads, right? So legislation to kind of deal with that. We're still a little bit on a holding pattern because that case right now is up at the Court of Appeals. So we're waiting to see what happens with that. But that's kind of one of the other issues that we've got our eyes on. Priority lien. So in 2012, we got a priority lien, but it was not a great priority lien. It was, so what it meant was that if a bank foreclosed and they asked for a payoff, we can provide them a payoff for, in addition to the amount they owe from the foreclosure sale forward, we can also give them 4 months or up to $1,200 of what the prior owner owed, okay? But that excludes late fees, interest, fine, it's just clearly assessments. The point of the priority lien, or the hope that what the priority lien will do is that it somewhat compensates you for the fact that these lenders are not foreclosing. In DC, actually, a homeowners association or a condominium used their priority lien. They have a much better priority lien statute. They used their priority lien to actually wipe out the bank's interest, and that's a pretty good priority lien. Maryland doesn't have that same type of structure. It doesn't. The law isn't written that way. It wouldn't give Maryland the ability to do it. But that's one of the other kind of hot button things that we're looking at. So if you guys have, I'll end my kind of legislative forecast. But if you have specific issues, feel free to email me. I'm happy to bring them to the LAC. I know certain areas, certain condominiums and homeowners associations have different issues, so feel free.
Just a general question. For the last several years, there's been legislation proposed that contains, in one way or another, requirements that HOAs and any community association register.
Yeah.
And then we're required to pay a fee, and so on. Required to go for education.
Yeah.
Is that coming back again?
I suspect that it will.
Why?
I suspect that it will. So my understanding of this, kind of behind the scenes, is that this has to do with kind of long-term manager licensing.
Right.
And by registering all the associations and kind of figuring out how many there are out there, and it kind of sets the framework for the argument for manager licensing. So I anticipate we're going to see it. The legislature has given up on manager licensing the last 3 years, and in lieu of that, kind of proposed that bill. So I haven't heard one way or the other, but I wouldn't be surprised if we saw
Will
it.
CAI take a position?
I'm sure we'll take a position.
You understand that we think if that's the issue, go through the criminal courts.
Yeah, I'm sure we'll take a position. I can tell you that the LAC is very heated when that bill comes up because people don't want to support it because they see manager licensing coming down the pipe. Other people want to support it because they think it's, we get in with some of the legislatures and let them win this battle, but we're going to fight for other legislation. So we'll absolutely take a position because it's a bill that's directly on point. What that position is, I don't know.
I don't want to argue the issue here, but
no.
Our position is, if you want to license managers, fine, but don't make us pay for it,
Yep.
don't make us register for it,
Yeah.
and don't make it harder to find volunteers to work on these boards if they have to go get more education,
Yep.
et cetera, et cetera.
Absolutely, absolutely. So that's the 2017 Maryland legislative forecast. Feel free to stop me if you have any questions. How are you doing on time today? It's 4:45. Okay. So I also have federal legislation in there. There's some changes with FHA. And there's also some interesting things, Montgomery County, PG County, Howard County. Feel free to come talk to me afterwards. I'm happy to kind of give you an additional mini seminar, but I want all of us to have time to present. So thank you guys so much. I really appreciate it.
Good afternoon, everyone. I do want to begin by thanking ACM for inviting us to come. We only just recently started working with ACM on properties at the moment here, front row. We've really enjoyed the relationship and look forward to continuing to grow with ACM and representing community associations. It is true that we have the slightly more exciting topic.
I take offense to that. Legislation is extraordinarily exciting.
But I was going to step back and say that it's not at all the most important topic. The laws that govern community associations are so important, and it is very important for all of you as already volunteers to take an interest and to take initiative to support the Legislative Action Committee, to talk to your representatives and to make sure that you vote to help address a lot of the issues. The 11114 statute, I'm sure we could have very lengthy seminar on all the nuances of that. But to jump into the collection, so I think everyone has a flow chart. I don't know if you got colored copies. We have a few up here if anyone wants them. The question that was asked is, what are some alternative collection options? And in order to understand the alternative collection options, you first have to kind of frame the standard collection options. So community associations are unique in that they have two different collection remedies. There are more, but two primary ones. And those are categorized as in rem, or against the property, or in personam, against the person. And a lot of you know those as liens and judgments, is basically the way that boils down. The in rem process is incredibly important. Under the Maryland Contract Lien Act, you're entitled to secure your debt, if your governing documents have language in there addressing that as well, to the property. And once you have a lien recorded, then that means that the individual that owns the property can't sell, transfer, or refinance that property without resolving that lien. I guess it's possible they could transfer it, but there would be problems with title in doing so. And the liens also give you the right to foreclose on those properties, though foreclosure can be expensive and nuanced. The other remedy, the in personam remedy, is where you get actual personal judgments against homeowners. And this is where all the fun discussion really comes in, where you can start talking about bank garnishments and wage garnishments and seizures and things like that. And under the in rem, there's really the only primary alternative there is that a lot of associations don't exercise is foreclosure. And we could talk at length about foreclosure. As was mentioned, there's a lot of statutes out there relating to the process. But at the end of the day, one of the problems that community associations have with engaging in foreclosures is that there's a lack of equity in the properties. Especially since 2008, a lot of properties have been underwater. So that means that you go through the process and then you find somebody who's not willing to bid enough to actually resolve the property and have it go forward from there. And also the process can be pretty expensive just to get through the advertising and all the notice requirements for it. So for community associations, a lot of focus goes into securing the lien and resting on that lien, and then at the same time focusing on the in personam remedy, and that's where you file a lawsuit against the individual homeowner. And if you look at our little flow chart, the lien process is pretty straightforward. It starts on the right side, or I guess it would be your left side, my right side up here. And then you move over to the lawsuit process. The reason that you exercise both remedies at the same time is because through the lien process, you can secure, the Maryland Contract Lien Act says, the language, the hot button language there is legal fees as awarded in a contract, or as allowed for in a contract, or awarded by a court. And the reason that's so important is because once you have a lien on the property, that can secure all of your legal fees incident to that lien and can help you make arguments to recover all of the legal fees that are associated with the collection process later on when that lien is going to be resolved. And the reason that's so important is because in courts, judges oftentimes don't award the exact amount of legal fees that were charged incident to the action. So when you go all the way through and you get in front of a judge, let's say you had a $1,000 balance, the judge might only award you $250 in legal fees, and you might have had $300 in legal fees, or different ratios of numbers with that. And the problem is that then the association has incurred a $50 of legal fees that's not secured by a judgment, and you can make arguments about how that's secured by the lien. And the reason that all works together is because through the collection process, you're working on both of those remedies simultaneously, and the hope is that eventually you're going to be able to recover the full balance and have a net zero legal fee for the association.
Briefly too, and Justin was probably going to hit on this, but I'm going to interject. On the lien issue, it's also important that people file bankruptcy, because if you have a lien on the property and someone files a Chapter 13 bankruptcy, for the most part that means you're a secured creditor and that you're going to get all of your fees still. So it's not wiped out by the bankruptcy. If you don't have a lien on the property and someone files a Chapter 13 bankruptcy, you might not be a secured creditor. So that's an important part of the lien as well. The other thing is on the foreclosure action, just like Justin said, not only is it costly, but it's time consuming and lately because there have been so many foreclosures, it just takes a long time for it to get the petition filed, to get the person served, if there's any motions filed, the advertisement, then it goes through the audit, and sometimes you go all the way through that stage, and like Justin said, no one bids on your property, then you don't get the property. It has to be someone coming to the bid at foreclosure, usually bidding what's owed on the mortgage, if there's any tax liens on the mortgage, any other liens that are in front of yours, plus your association needs in order to go forward.
And there are much more cost-effective strategies through the in personam process, and we're going to talk about a couple of those. I'm sure most of you are familiar with bank and you have a question?
Just a quick one. You've got a little note that says the lien is good for 2 years. Is that true?
That actually is inaccurate. Under the Maryland Contract Lien Act, it says that you're supposed to update the liens 2 years within the breach of the contract, and that's where that is. That needs to be changed on the flow chart, but you're supposed to update the liens every 2 years. There are varying opinions on that. Some attorneys update them yearly. I think that's, I don't know what your firm's position is on the issue, but generally speaking, under the Maryland Contract Lien Act, liens are updated every 2 years.
And a lien
So
is
if you want to
actually,
keep it alive, you have to revisit it?
well, the lien is going to stay alive. It's not going to go away. So if you filed a lien in 2001, it'll still be on the property if it's unpaid. And I think she hit on it. If you go to transfer your property, most title companies will come up with every lien that you've ever filed, and you can bring it to date. So it's not going to go away. But the Contract Lien Act does say that you should reinforce it every 2 years. So we always advise our clients, make sure that you have a lien at least every 2 years. But it's not going to go away unless
But
they're
that
paying
costs
for it.
money.
It does cost money.
It does.
Why would we do that if we didn't really have to?
Well, if you're constantly, and your management company is looking to make sure they didn't pay it off, but what happens is some homeowners make a payment or two, and then that 2001 is paid off, but they still owe $5,000, so you're thinking, oh, we're protected by that lien, but in reality, they've really paid that lien off, and now it's new amounts, and so you don't want to lose that ability. And if you haven't done it within the 2 years, that's why.
Also, if the amount changes of the lien, you have to redo it.
No, what I'm saying is that if you filed something in 2001, let's say, and then the homeowner started making payments in 2010, and the payments go to the oldest debt, that 2001 lien may be paid off now, and then you're not protected if you're not watching that closely.
And also, updating your liens periodically can help you in the Chapter 13 bankruptcy, because when you're making an argument about the secured creditor, they look at the base of the lien, and if there's a challenge there, you can use that as a threshold for it. Yes, sir?
The lien is created on the property according to the governing documents, like ours written in '79. Does that hold any water? Because the attorney we use, they file another lien.
Yeah, so there's a distinction between and in DC operates a little bit differently too. There's governing documents act as an encumbrance to the property, right? So just by virtue of having those, there should be a request anytime there's a transfer of property to ask what's owed or what's owing to the property. The problem is that a lot of times title companies look only to the recorded liens under the Maryland Contract Lien Act, and a lot of governing documents will say specifically that in order to secure the lien, you have to record it per the Maryland Contract Lien Act. So there are arguments to be made if there are not liens filed, but they're not necessarily, they're going to be specific to each association and how those arguments can be crafted. But more importantly, it's not as favorable to an association to just rely on your governing documents as if that's going to result in being caught for the delinquency as the transfer comes about. And it also doesn't help you in the bankruptcy situation too.
Yeah,
you can make arguments, but
yeah, Maryland is a recordation state, like Justin said, so if you're on record, they have an obligation to contact you to pay it off. If you're not, and you're just relying on your documents, the title search companies sometimes don't look to see what your documents say.
To shift into the in personam, so once you obtain a judgment, one of the things that we always encourage all of our clients to do right away is to record judgment liens based on that. The judgment liens are sort of a hybrid in the sense that they also bind the property that's recorded in that property because they come up during title searches, but they relate to the underlying judgment. Once you have that judgment lien in place, it can prohibit homeowners from selling, transferring, or refinancing anywhere in that county. In fact, you can record them in additional counties as well. So if you know that a homeowner is renting a lot of property in one county but has a single family home or something like that in another county where they're living, you can actually record the judgment lien there and potentially encumber additional properties when they go to sell, transfer, or refinance those properties.
Yeah, we've had associations have their assessments paid off because they had a property in Prince George's County, but we knew and we thought a judgment lien was as a result of the lawsuit judgment. When they went to sell a house in Howard County, that lien came up, so they call our office and say, is your judgment lien paid? And then we can get all of the association fees, even though that person doesn't live there. Yes, sir?
Can you do that for Virginia or out of state?
I'm not licensed in Virginia, so I wouldn't be able to tell you specifically in Virginia. Maybe
Virginia, is it valid in Virginia?
I'm not sure how the judgment lien process works in Virginia.
So it's actually somewhat similar to Maryland. So once you file it in the court system, it's docketed, it creates a judgment lien, and then you can collect on that judgment lien, and it's effective throughout that county.
And the reason I bring that up is that our community is transitioning over to mostly rental properties, and the owners are leaving the state. So when we go back to check, we're finding issues that they're not recording all that information. So we found a couple of owners who are actually moved over to the state of Virginia, and they're behind in their assessments. So
Yeah, so what you would have to do is actually domesticate and enroll that Maryland judgment in Virginia.
So you would take the Maryland judgment, just like she said, and
Yeah.
get a triple seal copy of it. If you know where that person is, then you take it to the state and enroll the judgment there. So that's pretty much any
Yeah,
state
pretty
across the United
easy. You
States.
just go through the judgment process in Maryland as you normally would, and then you just get copies, like certified copies of the judgment, and walk over to the clerk in Virginia, docket it. I mean, it's obviously not that easy, but it's pretty easy. You docket it, and then it becomes a judgment in Virginia. So then you can collect, in addition to all the assets that they have in Maryland, you can garnish rental income in Virginia, or wages in Virginia, or...
Absolutely, and most firms that are working in this area have relationships with either attorneys that work in other areas, or they have licenses. We have one attorney who's licensed in Virginia in our office. So there's different ways to transmit judgments, and we actually see it all over the country. People leave from here. We have cases that we're working on with other attorneys in Texas and California. I think we have one in Michigan where we actually did a bank garnishment through there too, and successfully hit on that. So it's a process that can be done. The most important thing related to collections, and this gets into the post-judgment collection, is making sure that you have as much information as possible. So one of the things that our office has done to really help make sure that we can get as much information is change our system from the old law firm operation of having paper files to having everything in electronic or paperless format. And what that helps us do is it helps us get more data in front of us faster so we can learn information about where homeowners go. Let's say they make a payment from 2012 to the property in Virginia or Michigan, and then 3 or 4 years later, when we go to pull up John Smith, we can see that payment in our system and figure out the address that was on there. So one of the big things about collections is information, and the more information you can get, the more information you retain, and the easier that is for you to discover in your file, the more successful you're going to be. Some of the other options, I'll let Linda talk a little bit about rent garnishments.
Yeah, and once you have a personal judgment against someone in Maryland, like Justin said, we have a lawsuit, now we have a judgment. Pretty much everybody knows about wage garnishments, bank garnishments. Those are the two things we use a lot in our office. But you can also do rent garnishments. If you know that the unit is being rented, then you can file, it's almost exactly the same as a bank or a wage garnishment. You file it in the name of the renter if you have it, which is perfect. If you don't, you just know renter occupant, we've also filed those as well. You serve that garnishment on the renter. The renter from that date that it gets served forward has to pay the rent to the association or to their attorney, and they can't get evicted. So people are like, wow, we don't want the renter to get evicted, but they can't. It's a court order for them to pay the rent to the association. It usually gets the landlord owner's attention, and that's what we really want as well. And we work a lot, and it's on our little flow chart about doing promissory notes, and that's one way to get a landlord's attention is to attach the renter's rent for the month, and then we can hopefully get the landlord's attention, get them on a promissory note. So again, it works the same way.
Excuse me, Linda, how is it that it's done if you don't have the name of the renter?
If you don't have the name of the renter, we filed it as renter occupant and use the address. You have to serve that person. You may have to prove to the judge that it is the renter. It's obviously better if you have a lease and the name, but a lot of off-site owners don't give it to you. So you know someone's in there, but you don't know their name. So it has worked for us in Prince George's County by doing it renter occupant. And again, you have to serve. Some judges want to make sure that you serve the right person. You may have to have them come to court, but again, it works.
Okay, thank you.
How difficult is
Promissory
that
note?
to do?
Yes, sir. Pardon me?
How difficult is that?
How difficult? I don't think it's any more difficult than wage or bank garnishments. We do it on a regular basis in our office.
The biggest obstacle would probably be service on that, making sure that your service is sufficient on the renter or occupant, and the court could take issue with that, but we do it rather successfully frequently, and the more information you have as an association or your management agent has about the leases that are in your community, the easier that process is to do.
And then the renter, once they get served, they call us as well, because on the document that we serve them, it has our name and our phone number, so they're calling up and they're like, wow, I don't want to get evicted from my unit, is the homeowner not paying the assessments, what can I do? So again, it's important for intention getting and get somebody called to the table to get the amounts that are owed to the association.
So in short, you're saying the renter pays the rent now to your firm?
Yes, has to pay it to our firm, and then that goes to the association dues. And sometimes the renter doesn't do that. There's documents that you can file that they're in contempt of court, but again, most of the time we're doing it to get someone's attention, obviously getting money, but you get the homeowner and the renter's attention too to bring them to the table.
If you know the renter's name and you serve them and you have proof of service and they don't actually respond to that writ to pay the rent, you can actually motion with the court to obtain a judgment against that tenant, and then you can seek recovery through the tenant as well. Again, it's a process, so there's a lot of little steps to it to get it to happen, but it is something that we've done before successfully. You can just like if you serve an employer and they fail to respond to a wage garnishment, you can motion the court and obtain a judgment against that employer. This happens a lot with independent contractors, particularly real estate agents. We find that they're always the response is always they're an independent contractor, so they don't have to withhold wages. We make arguments about that. We end up filing a motion, and then eventually we start seeing some compensation coming back to the association.
What kind of fees are we talking about for lawyers? I mean, earlier you said something about, well, $300, and I'm thinking, where do you get a lawyer for $300?
Prince George's County. I
can answer that.
That is a fantastic question. So, and that's one of the things I'm going to get at later, is one of the most important things for being effective at collections is not really all of the, every attorney that practices in this industry is going to use the same tools. The forms are the same. It's just plugging in data. And the way to make the process work for community associations is to do it efficiently. And that's one of the things that Linda started doing starting in the 90s, is created a program in our office, it's in-house, to help make this process efficient. And by being efficient, we can keep our fees proportionate to the work that's being done. We have an association, by way of an example, that has annual assessments of $65 a year. $65, not a month, a year.
Wow.
And they have collection problems, believe it or not. And we're able to effectively represent them. And on the other end of that, we have associations that are $1,500 a month. You just have to keep in mind that the way that you're structuring your relief to the collection file has to be proportionate. So when you get to court, you can make a good argument about why your legal fees ought to be rewarded or awarded. And also you have to have a willingness to adjust legal fees to make it work for that particular particular item if necessary.
Our firm has a flat rate fee, which is pretty, somewhat different from, I think, most firms in Prince George's County, at least anyway. And so you know upfront what you're going to be charged. For example, a rent garnishment is $75. So $75 you can afford to try it, plus your filing fees. But again, you have to look to see what the fees are, and you, as a board, as an association, you have to make that financial determination. Is it worth it to file this documentation for, you know, a $200 debt? Maybe not. But again, if your fees are reasonable, it's worth at least trying the rent garnishment or wage garnishment or bank garnishment.
I mean, I got a legal opinion, and it cost over $800.
You didn't come to my office.
And here's the thing, there is a distinction between that type of work where you're seeking an opinion on something which can involve a tremendous amount of research. It could also involve not a lot of research. But the hourly rates that kick in for that type of work can be very, very different from the collection fees that are associated with community association.
And again, depending on your opinion letter, somebody may have had to read all of your documents, look at the statute, kind of depends on the opinion letter. But again, if you know your flat rates up front, then as a board or as an association, you can make a determination, is it worthwhile financially for to try to pursue this amount?
But it is important to know that your attorney is aware of that cost-benefit analysis. So I mentioned earlier that there are attorneys that file liens every year. There are attorneys that file lawsuits on every single account every year, but they don't have a lot of effective work going into post-judgment collection efforts, okay? And that's really the bank garnishments, the wage garnishments that let the money actually come in. So rather than spending every single year filing a lawsuit, maybe you wait every 2 years, or in the case of the $65 a year assessment, you wait right until the 3 years runs, and then you file your lawsuit and try and get the legal fees proportionate to the principal balance that's owing, so that the court looks at you seriously, and then you focus heavily on the post-judgment collection work in a cost-effective way. It's one thing if you have a $30,000 balance that you're trying to collect on, and you know that they bank at one of 5 banks, so you throw out 3 or 4 bank garnishments. That could work very successfully there, but if it's a very small balance, $1,000, you maybe don't want to spend a lot of money chasing 5 different bank garnishments for that one particular judgment. You want to be a little bit more precise. So maybe you wait for data, maybe you go on Facebook and see where they work. There's a lot of different ways to do it. But
that's why we do promissory notes a lot too. And we had talked about, I think we hit on that a little bit, the statute of limitations issue, and promissory notes sometimes help with that. Again, if a homeowner has over 3 years, but they've agreed that they owe that amount, and you get them on a note, that may be one of the issues that you can get around the 3-year part. Have to be careful about that, but there are ways to do it. And the promissory note also, I don't know if a lot of people know this, but you can get a lawsuit judgment in Maryland for the full amount owed. All your assessments, all your late fees, all your attorney's fees. But then that homeowner walks out of the courtroom and you don't know where they work, or where they bank, or where any of their money is. So now you've got a great judgment, but you can't collect on it. And then you're spending hundreds of dollars to try to collect on it. And there is a process, and we're good at that as well, but if you have a promissory note like we do in our office, it's a written agreement that says what they owe, what they're going to pay every month, they're going to stay current with their assessments now and something towards their arrearage. We have default provisions in it for legal fees and late fees if they default. But we also have an information page that requires them to give us their bank information with a copy of a check, their wage information with verification, their social security number. If they have a renter, they give us their lease and the renter information. So if anyone defaults on that note, you're not starting the whole process over again. You've already got that collection information, and you're able to collect without spending a lot more money or any money filing a rent garnishment, wage garnishment, or bank garnishment. It also, again, gets the people to the table. If someone owes your association $10,000 and you're saying to them, we need $10,000 or we're going to continue to collect, it's unlikely they may have it. But if you come to them and say, you know, give us a couple $1,000s up front to show good faith, make your current assessments every month towards something towards the arrearage, give them some time to pay off, it helps them bring to the table, gets you money in the office to start, and all your collection information if they default. It's been a great tool for us. You know, we recommend it to all our associations if possible. Yes, sir.
I imagine a lot of people here have horror stories they can tell about collections and such. So my question is, in your actual practical experience, because I've only been at this less than 10 years, how does the current situation in actually being able to really collect, as opposed to the right to collect, compare with 10, 15 years ago, and what's the outlook for the future? We have many homes that are underwater, you know, we're so many, you know, down on the list of payees that, you know, there's no hope and, you know, all those kind of things.
There's no
What are the
question.
practical considerations on actually collecting?
Okay, well, first let's just tell what, we collected last year for our clients over $5 million. So that's a lot of money, and we're pretty good at it. But you're right. I've been doing this for 27 years as an attorney and 12 years before that as a paralegal and a legal secretary, so I know the difference. There was a time where if you threatened foreclosure on someone's house, they were in your office with a check because they had equity in their home and they didn't want to lose it. We're not there anymore. Although I can tell you, we've had 3 foreclosures recently that had excess proceeds, and because we had judgments and liens, we got money for our associations from the excess proceeds. So it is changing a little. The market's increasing a little. But it is totally different from what it used to be 10 years ago. But that being said, if you're efficient with what you do, like Justin had touched on earlier, if you don't wait too long and you take action to get a lien and lawsuit judgment against homeowners before it gets to 10,000 or 20 or 30, if you bring people to the table and you talk to them, in our office, for example, if a homeowner calls, we talk to them and don't charge them. Because if they're willing to come to us and talk to us and work out a payment arrangement, they don't want to say, wow, it's going to cost me a couple $100 just to come talk to you to work out an arrangement. When we get them on a promissory note, we keep the note going during the whole term without charging the homeowner again. So the homeowner's not saying to you, wow, I entered into a payment arrangement, I'm making a $300 payment every month, but $50 is going to Cameron Mericle. So once we do the note, we don't charge the homeowner anymore, as long as they make their payments and keep current. So again, it's another way to bring people to the table, make them understand if they start paying, which they have an obligation to do in order to stay in your community, that they can bring the debt down. So practically, for us, I think it's working. Now there's no question we have some associations that waited way too long and that are in the 5 figures, which they're not happy about and we aren't either. But there are some things that we've been doing with regard to those large accounts as well. Justin's way better than I am because I'm older and not as good on the computer, but there are a lot of sites that are like LinkedIn and other places where we've found assets where, you know, our firm didn't used to be as productive in that area. Sheriff sales, that's been working for us, and I'll let Justin talk about that, but sheriff sale is something you can do after you have a lawsuit judgment against someone. So if you have a large account in your office that has a balance that's been unpaid for a substantial period of time and you have a lawsuit judgment against them and they're living in the unit or they have someone else living in the unit, sheriff sale's been working for us.
But to answer your question a little more directly too on that, there are distinctions between the way that the collection industry has operated over the years, and there's a lot of factors that play into it. The biggest, probably, that most people are aware of is the housing crisis, right? When that happened, it changed the equity in the homes, and it really changed a lot of the collection practice used to be focused, and particularly I did this in Florida before I came up here, on just recording the liens, waiting for the payoff to happen, because people were constantly refinancing prior to 2008, and that resulted in a lot of money coming in to associations. You just record the lien and rest on it. Well, now there was a lot less transferring that took place for a while, and then you also notice that there was a huge distinction between different segments. So condominiums in particular, I think, are struggling more so than a lot of homeowners associations financially because they have bigger capital expenditures, and they've had an in this no-fault insurance scheme with 11114, and a lot of different factors can go into increasing the assessments, which makes it harder for people to sustain those properties. And at the same time, the property values are going down, so you get lower income people purchasing a condominium with higher assessments proportionate to the property value. So there is a problem, and hopefully we can get some legislation to change the effect of 11114 and some of the other things that are affecting community associations. But what you're looking for, and really, is to sustain your collections. There's, like I said, the one with $65 a year, they have collection problems, and the reason is because people misprioritize their obligations, and you can't fix that. There's no way to say that you should pay this instead of your cell phone bill or whatever it is that they're paying. But what you can do is create a process that's effective and timely that makes a homeowner understand that if they don't pay this, that there's going to be consequences. For some homeowners, just receiving a letter with the power of legal letterhead, they'll pay. Other homeowners, it takes all the way up to the day of a sheriff's sale eviction for them to come to money. And with that, I can go back and talk about that more, but I'm going to shift into the sheriff's sale issue, because that's one of the alternative strategies that, quite frankly, our office didn't use a lot 10 or 15 years ago. It was reserved for really those extreme accounts, and now we implement it quite a bit more. The risk associated with doing a sheriff sale is that you can encourage homeowners to file bankruptcies to avoid the process. So a sheriff sale is basically you're levying the homeowner's interest in the property through the sheriff's office. So they go and they notify, or they stick notice on the door that this property is going to be levied pursuant to a judgment, and the sheriff you'll coordinate with the sheriff's office and have a sale. In Howard County, they do it at the property. They actually just changed that because we've had so many up here where they've, what county are we in right now, actually? Howard County, all right. I had to think about it geographically. But in Howard County, they changed it. Now they're going to be doing it at the annex courthouse building. And in Prince George's County, they also do it at the courthouse in Montgomery County as well. But that, where they actually go and they bid up to the judgment amount that was entered. So let's say somebody owes $10,000, you might only have a judgment for $3,000 because of service issues or whatever took place. But at that sale, you can bid up to that judgment amount. And each county has different rules about deposits and things like that. But when you bid as the creditor, the association, you basically just bid up to the judgment amount, and if that homeowner doesn't outbid you, or if nobody else doesn't outbid you, then you obtain that homeowner's interest in the property. The way I've phrased it is that you get a greater possessory interest than the homeowner by virtue of the sheriff's sale. And with that, you can actually coordinate with the sheriff's office and schedule an eviction. There's a ratification process. There's lots of little baby steps to all of this. I'm trying to give the big picture of it. It can take a while to happen. I think on average it's about, I've seen them happen as fast as 6 months, and I've seen them take longer than 18 months from beginning to end. Just depends on where you are with the judgment, how fast the sheriff's office is, and everything like that. But the goal is for us is to get everything out of our office as quickly as possible, so it's sitting at the courthouse or the sheriff's office and waiting on that process to take place. So some people respond right from the day the sheriff levies the property. And by response, I mean they either file bankruptcy or they call us and work out payment arrangements, or sometimes they just pay in full. Other people, they wait until the date that that sale's happening. I actually had somebody show up at this courthouse steps and film the whole thing and threaten and all of that. And then, of course, a couple days later, they came up with the money to stop it. And other people, they don't pay at all. We just did an eviction in Greenbelt just last week. In fact, I have 2 scheduled for tomorrow, 2 evictions. So it's a process that can be very effective, but it also can create a lot of hostility in certain communities. So you have to be, I mean, you guys, you're trying to be good stewards of your association's money, but they're also your neighbors, right? So they can fall into hard times, they can have different issues, and so I always encourage my board to be sympathetic to those issues, but at the same time keep in mind your obligation to make sure that everybody's paying their fair share towards the association. So delaying an eviction for a couple of weeks while the homeowner gets some money together, that's something that you can do, but it takes more time and energy to make that happen.
Yeah, and the reason we're doing the sheriff's sale again is to bring people to the table, to get them on a payment plan, to get money into the association, not really evicted from their home. That's not really what we want, but at the same time, at some point, some homeowners and condominium associations say you cannot live here for 7 years and not pay. You just can't. So if you're not willing to pay and you're not willing to work out some arrangement, then you may be evicted. Now, it may not get you the money all the time, but it'll at least get you a new owner in there who's not living there for free.
And I just, to dovetail on that a little, I know there's a couple more questions, but I might be able to address them beforehand. But one of the questions that was asked from ACM prior to coming here is, what are the statistics incident to this? And I tried, but our system has a lot of different ways we can run data, but there's no real clear way to say this many sheriff sales resulted in this type of action, because everyone resolves slightly differently. Some of them, we had one where we initiated it and all of a sudden they came up with $20,000 to stop it. Another one, we had different judgments for different amounts. So the first judgment, they came up with $10,000 to resolve that judgment, and then we had to initiate another sheriff sale. So there's different homeowners respond differently, and the second sheriff sale in that second instance is actually scheduled to go forward with an eviction. So there's no real way to say how it's going to happen. We have seen bankruptcies coming from them, which can delay the collection process, but it's not necessarily the worst thing for a Chapter 13 bankruptcy in particular. Yes, sir.
In terms of expense compared foreclosures and time,
Yep.
how does it compare?
So time can be comparable, but generally it's
usually
shorter.
Time, cost way less.
Yeah, our office, it depends on the county and the different rules, but from beginning to end, the process for our office is about $2,000.
Could you, couldn't hear that question.
The question was about the cost and the time. So foreclosure process can take longer because there's more motions and things like that. But I have seen sheriffs drag this thing out for a long time. So I mentioned earlier, 5 to 18 months is pretty much what we're seeing on beginning to end after you have the judgment in place. We try and get it on the shorter end of that, but there are obvious delays. And the other question was the cost incident to it. It is much cheaper. We find in the foreclosure process. From beginning to end for our office, it's about $2,000. It depends on what county you're in because
Sheriff
it's
sales,
the
$2,000.
sheriff sales.
Foreclosure is way more.
And when I say that, I'm not saying like that's post judgment, but it depends on what county you're in and things like that. And also, you should know this too: the sheriffs in different counties have different deposit fees. So, like for instance, in Howard County, in order to initiate a sheriff sale, you have to have a $5,000 deposit. You pay $750 to the sheriff's office for a fee. For the auctioneer, he's a good guy. And then you also have to bring $5,000. It used to have to be in certified funds, but they let us do personal checks from our office now. So there's a lot of money incident to getting the process done, but all $5,000 of that almost comes back to you. They just take out the auctioneer's fee and things like that.
Justin, there's some other benefits, non-monetary to it as well. In my experience, these people that are so delinquent, there are a host of other problems associated with them, whether it's parking issues or architectural violations. By doing the sheriff's sale and getting these people out of the community, in one particular instance, we're looking where a homeowner turned his townhouse into a boarding house with like 6 tenants with 8 to 10 cars associated with that property taking up parking. By doing the sheriff's sale and getting them out, you're not only trying to recover financially, you're ridding your community of blight.
Can help property values come up after that too. And the one thing that, to clarify too is, after the sheriff's sale takes place and you get the ratified deed, there's this big gray area about what you do with that deed, right? So some associations, they want to record that deed and then try and rent the property out and try and make some money for the association until usually before the first mortgage comes in and eventually forecloses on the property. We've done these on properties that actually have no first mortgage. So it's possible to actually get relatively clean title. There were some judgment liens in place from other creditors through this process, and then you can actually, as the association, you record your deed, you engage a real estate agent to help facilitate a short sale. If there are already encumbrances, try and negotiate those, or to just list the property and try and sell it to resolve those. Yes, sir.
What if a bank holds a mortgage on this property? What do banks do when you do a sheriff sale? Do they come in and foreclose?
They can. So that's the one thing about sheriff sales that's distinct from foreclosures. When you finalize a sheriff sale, the banks will routinely do nothing through the process, but they could at any time foreclose, which means that you could start your sheriff sale today, 6 months later, the bank started their foreclosure process, and then they extinguished the liens on the property, everything through their foreclosure, and you just basically wasted money for that sheriff sale process because it doesn't really get you anything. I have one right now where there's a foreclosure process. This is the eviction for tomorrow. There's a foreclosure ongoing right now from the bank, and the association last night was saying, do we pay for the eviction crew to actually evict them? When if we just did nothing, the bank would foreclose on them and probably evict them 6, 7 months later. Well, the association chose, because it's like Bill said, it's a problem in the community, this particular home, and they're trying to set an example. And it can have great effect, especially if it's the house at the front of the community or somebody that everybody knows about. We've seen a lot of other homeowners contact our office after an eviction takes place in the community.
But yes, the bank can foreclose. The problem is, and I think she touched on it a little bit when she was speaking, you just don't know how long it's going to take. We have some homes that have had a foreclosure started, and it's 2 or 3 years later, and they're still not moving on with the process.
Or we've had 4 years, I think.
4 was, I think, the longest. So you just don't know how long they're going to take to foreclose. So if you're at least to the sheriff's sale, you've gotten that person out of there and can take some action to help your community and hopefully take other actions to get a new person in there.
So the one thing that can be problematic, a lot of people after this are gonna say, why don't we start doing sheriff sales on properties? Right, that's the first thing that everyone says, and whenever that comes in, again, that cost-benefit analysis has to be the first thing you do, right? Even though it's not incredibly expensive, you still don't wanna be putting $2,000 to collect a $3,000 judgment through this process. This sheriff sales statute does have some language in there that allows you to recover some of the cost incident. You can make arguments about that as well. But you've got to keep that cost-benefit analysis in mind. For some people, they'll just go file a bankruptcy that's a couple $100 for the filing fee to stop the process altogether. So each account's going to be fact-sensitive to whether or not it's viable. Usually my threshold is the balance should probably be somewhere close to or north of $10,000 before you really start doing that because of the problems that can come from it. Another thing to keep in mind is that with the I lost my train of thought. Yeah, if it's a vacant property, that could be something that you don't want to do a sheriff sale for because it really doesn't get you much. It doesn't put a lot of pressure on the homeowner. Now again, there are associations out there that do this and then start renting the property out. There's a whole other host of liabilities which you should talk with your attorney about if you're going to do that too.
Yes, ma'am.
You keep mentioning if there's a Chapter 13 bankruptcy, it can help, but what about other forms of bankruptcy?
Well, I shouldn't say it could help is sort of maybe a stretch of the word. So bankruptcy, Chapter 13 bankruptcy, you want to take this?
Yeah, Chapter 13 bankruptcy, if you have a lien, you're usually a secured creditor, which means you're going to get paid in full. Which means from the day they file bankruptcy forward, they have to stay current with their assessments, or you can file what's called a motion to lift stay to collect that post-petition. What they owe on the date of bankruptcy filing for a 13 goes into the proof of claim, and you get paid over a 4 or 5 year term. So that's the protection of the 13. On a 7, you are not a secured creditor if you have a lien in that you can't go after them personally, but that lien stays on record. Maryland law is a lien does not get wiped out by a Chapter 7. So if a homeowner files a Chapter 7 and you have a lien on the property, it doesn't get wiped out by their bankruptcy. You can't go after them personally for that amount, but at any point in the future, if they sell or refinance or transfer their house, as long as they remain in the property after the foreclosure, you'll get paid under that lien. And from the day that they file the Chapter 7, if they filed it on October 1st, let's say, November 1st, they have to pay their assessments. If they don't, you can take action there too. So those are the two main kind of bankruptcies in Maryland, 7 and a 13. There's 11, but that's a reorganization that's usually commercial.
It's kind of similar to 13.
Did that answer your question?
There are exceptions to all of that stuff.
So if they file a Chapter 13 bankruptcy, you can go after them with a personal suit?
Well, you can only if they don't stay current. Okay, so if you have a
If
lien
they
on the
don't
property.
stay current, but if they file a Chapter 7, you can't do that?
Right.
Okay.
And there's actions you have to take in order to go after them personally. Like a 13, you have a lien, they filed on October 1st, December 2nd or 3rd or January, they haven't paid. You have to go through the court and file what's called a motion to lift stay. You tell the court they're not staying current with their post-petition payments, and you get an order from the court that lets you go after them personally for the post-petition amounts of money.
And some judges push back in the bankruptcy court on that and don't give you the words that you want in the orders. And it's subject to motions and lots of things. But by and large, that's how as Linda's describing it, that's how it works. At least that's how our office has been able to resolve a lot of those. There are also potentials through the bankruptcy process where they can file motions to avoid liens. So if the homeowner feels that the lien is unsecured to the property because the property is so far underwater, they can file a motion and potentially get the lien set aside. So there's a whole host of things that could come about through a bankruptcy that are not ideal. So that's and it can in Chapter 13s they can drag on for 3 to 5 years with that automatic stay provision in place. So sometimes, particularly if you have problems in a home, those bankruptcies might not be the best way to address the problem. Or the sheriff's sale might not be the best way to address the problem instance because they could file a bankruptcy, which then makes you have to go through the bankruptcy court to get additional relief.
Yes, sir.
Is it possible to file a small claims against instead of going through all this process? You know, like if they're in the arrears for, just say, I don't know how high small claims.
It's $5,000.
$5,000.
$5,000. So, I mean, if they're behind in their fees of less than 5,000, could you go to small claims and say, hey,
The process is exactly the same with up to $30,000 because it's all in district court. The only thing that's really different is the rules of evidence are lessened for the small claims process. The judgments, whether it's $4,099 or $5,001, they're pretty much going to operate the same way.
Yeah, so as long as you're not in bankruptcy, then yes, absolutely, that's what we do on a regular basis. We always say get the lien first because it's quicker and cheaper, and it protects you so they can't sell or refinance or transfer their house, and it protects you somewhat most of the time in bankruptcy, but you shouldn't stop on the lien. If you really want to go after them for the amount of money they owe, because they're going to sit in their house for the next 20 years, they don't care if there's a lien on their house. If you're going after them for the money, then you should do the lawsuit as well.
So one of the other alternatives for collection that I do want to make sure we get time to talk about is through the estate process. And I'll let Linda talk about that one again. And we can certainly jump back to sheriff sales or rent garnishments or anything that you guys want, but I do want to get through just a little bit of each one if you don't mind.
Yeah, I told Justin I wanted to just touch on this a little bit because I think our firm's a little bit unique in this area. I've heard from other associations and attorneys that if a homeowner is deceased in your development, that you just have to write it off. Obviously, you can't collect a debt from a deceased person. But what our office has done under the Estates and Trust article, it's 5104, is if there is a deceased owner and the person or family members are not taking any action to transfer that property and or to pay the association, we've gone into court and under the Estates and Trust article as one of the largest creditors for that decedent, you can have an estate opened up. So I go in regularly in Prince George's County, I think we have 10 right now, one in Howard and one in Montgomery, to just say, family member has not opened up an estate, the owner's deceased, the property sitting empty. Once they appoint me personal representative of the estate, then I can put the house on the market. I can locate other assets, do they have any employment benefits, do they have any bank accounts, and then I administer the estate just like the family would. I mean, I have a fiduciary obligation to make sure that I track all the funds, I can't spend the money without going through the estate court, but it gives you an opportunity to collect money if the family members aren't doing it. The other thing we've done is if a family member has taken over after a homeowner is deceased in your development, but they're not taking any action, they're again just living there for free and not paying attention to the collections, we've petitioned the court, one today, I meant to say that, petitioned the court to say that to the family member is not taking any action, they're they're not caring for the assets of the estate, so we had the brother removed from the estate and our office appointed. So again, we plan on listing the property. Hopefully there's some equity in it. If there's not, we do short sales on a regular basis. A short sale is when there's no equity in the home, but the mortgage company is willing to take less than what they're owed, but they'll pay some money to the association as well. So we've done quite a few short sales in our office. Saying to association, if you take $5,000 on a $7,000 debt, it's better than letting it go to foreclosure. And the banks are aware of that as well. Instead of us foreclosing, and we know this house is underwater, we'll take some money on the sale, on a short sale, and then move on. So we have a new owner.
So when you do that and open the estate,
yes,
then would you be shown on the records as a special administrator?
Well, I don't usually do it as a special administrator. I usually do
But
it as a
could be
person.
done
You
that
could
way?
be a special administrator, yes. But the special administrator has less ability to do some things. In other words, they have to go and ask the court, can I sell? They have to go, can I do anything with these funds? If I'm the personal representative under 5.4 as one of the largest creditors, then I have the ability to do anything under my fiduciary duties. That means I can close a bank account, I can sell the house, I don't have to ask permission, etc.
Because I know from one of our units where the owner died, they opened the estate real fast and they closed it real fast, and then the next thing you know, it was with the special administrator, which was not our attorney. So,
Yeah.
I do have a question for Justin.
Sure.
So is there a difference between a foreclosure sale and a sheriff's sale?
Yes.
When it's put forth by the condo when the condo association? And does the difference between those sales, does that have some effect on the amount of money you would need to buy the property if there no other purchaser?
So the foreclosure process is based on the in rem remedy, right? The against the property remedy, the lien. And the sheriff's sale is actually based on the in personam remedy, but it's sort of that hybrid one, the judgment lien that you have to have in place first. So they are distinct in that the sheriff's sale is actually through district court, if the judgment's under $30,000, and the foreclosures always through circuit court. So because of that, it's usually faster, usually cheaper, things like that. But as far as what interest you get as a purchaser at a sheriff's sale versus a foreclosure, it is different too. Through a sheriff's sale, you're taking only what I call is a greater possessory interest than the homeowner, right? So you're just stepping right above the homeowner, but you're still taking it subject to every other encumbrance that exists, whether it's a fence that's over the property line, whether it's a tax lien, whether it's a judgment lien, whether there's a
mortgage doesn't go away.
No.
anything else on the property.
But it doesn't go away in the type of foreclosure sale that we've been doing.
That's correct. It does, the foreclosure, the mortgage doesn't necessarily go away through the foreclosure process. The difference primarily being, though, that the sheriff's sale is not seeking to extinguish all of the rights on the property. You're just seeking to extinguish that particular homeowner's interest in the property. So there are advantages to both. They're gonna be a little bit fact sensitive because you want to make sure that you run title before you're doing foreclosure, so you understand all the encumbrances on the property, so you can give all the notices and requirements. And that's another huge distinction too, is the notice requirements for a sheriff's sale are significantly less. You don't have to notify everybody on the property, you're just simply notifying the homeowner that you're going to deprive them of their interest. So they are, the one big distinction is this: you could not do a sheriff's sale if you didn't have a judgment. So if you're having issues with service against an individual homeowner, that can really complicate your ability to do a sheriff's sale, because if you don't have that judgment in place, you can't exercise the sheriff's sale remedy. It's also called, and I actually kind of prefer calling it this, the writ of execution. So that's what's actually on the form. It's a little scarier, right?
And I have a question on the estate. How long do you have once you're notified of somebody of a death to start that process?
Well, you can start it any time. I mean, some people wait 2 years, or you can start it one day after. There's no requirement of when you have to file it after the person dies. You can, like I said, it could be 1 day or 1 year. Once you open the estate, you're supposed to try to administer it and close it within 9 months.
And the claim against the estate.
The claim against the estate is supposed to be filed within 6 months of the decedent's death.
Okay, so you're supposed to file within 6 months?
Yes.
But there's
That's a claim. Like if you're just filing, if you know the estate is open, like we regularly check to see if we've heard that. If you know the estate is open, then your association should file a claim against the estate within the 6 month period.
From the date of death. So there's a distinction between petitioning to open up an estate as the largest creditor and simply filing a claim as a creditor. Yes, sir.
I'm looking at your flow chart.
And I'm way off of it, right?
No. And I'm looking down the lien process. And the last item down there at the bottom of the lien process is D,
Sure.
sheriff's sale.
Sure.
Now, you just said I can't do a sheriff's sale without a judgment.
You're absolutely right. The
And
reason
now I look down lawsuit process, and that's where I see judgment about the middle of the page.
Correct.
Now, how are those two connected?
Well, the reason I put sheriff's sale there is because it's a conversation that always comes up. Incident to foreclosures, it really is not a remedy under the lien process. It's a remedy under the judgment process. And I should probably, this chart probably has a couple of little updates. I think one of them was mentioned earlier as well. It gives you a simplistic view of the collection process, and that was the goal here. So for clarity, sheriff's sales are not a process under the liens. They're a process through the court system, typically through the district court. Preferably through the district court, actually, because it's all form-based and the sheriffs really understand that.
And you do have to have a judgment lien, so it is a lien, but not this type of lien. It's not in rem lien, it's a judgment lien.
Another
It's from the lawsuit side.
Another problem that can come up with sheriff sales too is, let's say you have two different homeowners, Jack and Jill, and if you only have a judgment against Jack because you couldn't get service against Jill, that sometimes the sheriff will not really let you go forward with the in fact, they won't let you go forward with the writ of execution unless your judgment lien is in the same name as the owners at the time you're trying to exercise that.
We have some deadbeat.
Everyone does.
No.
And
No one in the room though, right?
and they simply don't open the door when we have a representative knocks on it, so they can't be served judgments. Any way you think you know how to get hold of this?
Your process server, if they're good, and you can coordinate, or your attorney can coordinate with your process server to get them to fill out what's called an evasion affidavit. which basically is an affidavit that the process server says, I was here on 3 different occasions, I knocked on the door and the TV was on and I heard people inside, or so the car was in the driveway, different information about the fact that those individual homeowners are evading service. And you can actually then, once you have that evasion affidavit, go to the court and seek alternative service. In Maryland, it's not just we've tried it 100 times, you actually have to show that they're actively evading service. And usually that's done through an affidavit of your process server.
It's called a motion for alternate service, and then the order says, again, you have to prove that the person was there and they were evading. Sometimes proving that you tried to do it a second way, like if you sent it certified mail and they wouldn't pick it up. But once you get that order from the court, the alternate service is by regular mail and posting it on their door. So once you have that order, the service by the court is just by posting it and mailing it, and then you move forward just like you personally served.
I think there was a federal case that just came out where they granted alternate service by means of a tweet.
I was gonna say,
I read an article about that
recently.
You're served.
Just to follow up on that, in 2 cases in our community, there's a personal judgment. And currently, in Baltimore City, where we are, the sheriffs are too busy to serve them. So they're totally ineffective.
Yeah, each jurisdiction is going to be a little bit different in how those operate. And to be frank, we haven't done a sheriff's sale in Baltimore City. So it's going to be a little bit different. You're going to have to coordinate with the sheriff's office to figure out whether or not that option is available to you. If you're just using sheriffs to effectuate service, you might be better off using a private process server to maybe one if you're just talking about the service element of that. So there's obviously a host of, I mentioned in the outline some other alternative theories. One we've kind of brushed on is third-party liability. Sometimes a tenant will sign a promissory note. Sometimes governing documents will allow you to actually seek relief from tenants. I've seen that in some of the better drafted governing documents where it says owner or occupant shall be responsible for the assessment, so you can make arguments about other parties being responsible for assessments, which obviously the more debtors or the more people you can get as defendants, the more likely you are to recover.
Yeah, we've had parents sign for their children who are behind on their assessments, so we'll take a promissory note from anyone.
And with the bank liability, this one's a little bit of a stretch right now, but our office has explored and successfully initially obtained a judgment against a bank for what we call failing to foreclose or economic waste. Basically, they delayed foreclosing on this property for such an incredibly long period of time, and we were able to obtain a judgment in district court, and it was appealed by Bank of America to circuit court, and because of various evidentiary reasons, it was not upheld, but the door was left open in Prince George's County for suits to be filed against banks for economic waste or for failing to foreclose. Now, it's again one of those cost-benefit things, right? So you're really stepping outside of what's the easy collection path, and likely your bank's going to hire an attorney and fight it, and you can end up in a big battle over that. So it's not being explored much, but we have a couple of cases where, a homeowner got notice from a bank that they were supposed to vacate the property. They even have the notice, and the bank hasn't foreclosed for 3 or 4 years, and so they give that to us, and we talk about it with our clients and say, hey, look, not only do we have an argument against the homeowner for not having paid this because of the record owner, but potentially because of the bank's interference in this, there's some waste involved on the bank's part. So there's some sort of theoretical arguments that you can make about bank liability.
Yeah, we've also had banks change locks, and then they have servicing companies come in, but then 2 years later, they're still not foreclosing. So again, it's a cost-benefit analysis, but we think we would have a strong argument if we could put all those ducks in a row.
I mean, we have units that we've gone through the foreclosure process to some point, and some of them we foreclosed on, and the banks hadn't got a mortgage payment in 7 years.
Yeah.
It was like, what are you doing, guys?
Yeah. Well, we've taken a lot of the time, so there's obviously a lot more that we've addressed in our outline. We'd be happy to talk with any of you. We always are willing to come to board meetings to at least talk about these issues. Usually we come to the first board meeting at no cost, so if an association has a question or would like to talk about these more, both Linda and myself, we have 7 attorneys all together at our firm, so we can arrange for somebody to come and meet with you and talk about it.
This is a question for all 3 of you. Squatters, what do you do with squatters that are in vacant homes? The banks have foreclosed on them.
I could take what we've.
Yeah, we've talked about it. I'll give you the floor again since we've taken a lot of time.
No worries. And just actually to feed off of what they were saying, we actually sued Bank of America in Montgomery County, and we were forced into mediation by the court. But one of the good pieces about it was that the banks don't want these exposure, they don't want these cases to be out there. So ours was resolved. It was resolved by the board agreeing to take ownership, paying assessments from a certain date, but at least we were able to turn over the property. The bank ended up foreclosing on 2, and we did a deed in lieu of 2. So the door is left open, like Justin mentioned. There's some Florida cases, not really any Maryland cases, but it is something that's being explored by various attorneys, just to kind of address that.
So you guys want over squatters? I mean, people that, not the people that used to own it and got foreclosed on. We're talking people who notice this house is vacant. It's shelter over their head.
Yes. So we've actually had, this is very timely because I've had probably 3 in the last week. So what we've done is we've sent a notice to the bank that says you have squatters. There's a safety issue involved because we don't know who these people are, and they're a couple of our cases they were doing drugs and they were just wreaking havoc, and we don't know, they're not legally able to be in the unit. Change the locks. If you do not change the locks within 5 days, as a public safety, we are going in and we are changing the locks. If you want keys, call us. And we secure the unit for public safety, and that's in a condominium context. There's a right to enter, there's a right to inspect, and a lot of governing documents have enabling language and then the ability to assess the cost. So this context was in a condominium context, but
what about HOAs in towns?
So that's a little bit more difficult.
That's the problem.
Yeah. So that was a little bit more difficult. We've sent similar type of letters. The ability to change the locks is a little stickier in the HOA context. But we sent similar letters to banks on that issue.
I do think it's important, like you said, to put the bank on notice, because then you're going to expose them to the potential liability if they don't do something about it, so at least you've got it on record.
Well, we have in a few cases, and
The banks
they
that
don't
respond at all.
respond.
They don't respond.
Prince George's County has
Howard
it.
County.
Okay, but Prince George's County has a county person that you can contact about squatters, and sometimes they will get out there in 60 or 90 days. But I don't know, we could probably try someone in Howard County and at least get the process started to see if
There's one in Prince George's County. I know one of our managers since
Howard
like
County is
February,
pretty
March.
responsive.
Yeah, if we get in touch with the
February or March, and no one's
Oh, really?
The reality is that the process is not set up to address that insufficiently, right? I mean, there are things you can do, but there's no hard and fast option. Certainly putting the bank on notice, sending letters to the homeowner, the record owner of the property. Sheriff sales is an option that sometimes can help resolve that too, because if there is a judgment, you can exercise the right to take an eviction, particularly in a single family or townhome, as opposed to a condo. So it's just going to depend on any number of different issues.
And I did want to touch on something that you guys mentioned, just in the creative collection and kind of feeding back off of legislation in Howard County, Prince George's County, and Montgomery County. If a landlord is delinquent in payment of assessments, in Prince George's County actually also they have provisions that say if they have violations. So I think you had mentioned like their covenant violations. And if it's an investor owner or a landlord, contact the county and notify them, because the county has the ability to revoke the license. Revoke the license, not issue the license. We've done it a couple times in Howard County, and they've been pretty receptive to it. So just kind of another feeding off of what Linda and Justin were talking about.
What if the rental unit that you're dealing with a problem with is somebody that you already know is renting illegally, meaning they did not obtain the proper licensing?
So I would I would again call the county, notify them that they're leasing without a rental license, and let them invoke their process.
Because our documents require a copy of the lease, and there's several that we don't have it, so we don't have the lease.
Is it a condo? So you also have, you can go through the violation process and you can fine, you can do, there's certain mechanisms by which you can incentivize them to do that, but I would absolutely notify the county and start their due process as well.
In Prince George's County, it's actually, the county is affirmative on that. Before you can get a license, you have to get a letter from your association saying they're against it. Montgomery County and Howard County, I think, are a little more passive.
Just some extra
I don't know that if this would help the person who was asking about the squatters, but we're a garden condominium, and we've had trouble, though we've since locked our front doors, but we're still having a little trouble with people who come in and spend the night in our hallways or our laundry rooms or storage rooms, whatever they can get into. And in Howard County, you can do an agreement with a memorandum of agreement with the Howard County Police, and then you can have them come and put people off the property, and they warn them, and then the second time you can do a banning notice, and they'll serve the banning notice, and then if they keep coming back, they'll get arrested. So I don't know if that would apply to somebody squatting in a unit.
That's a great point, though. I mean, if you're having these issues, make connections with your county police officers. We have in Montgomery County, there's a police officer that we're in touch with that knows these problem units and is on alert, and we could call him and he'll come out. He actually condemned a unit that was in such disarray, but after, he got to know the association and the manager. So get these people involved in your communities to the extent that you need to. It's just another resource, just like you're saying.
It's helped us with some things. I'm
Absolutely,
not
right.
saying it's permanently solved them, but it's helped with move unwanted people from our premises.
Thank you very much.
Thank you, everyone.
You're welcome.